Public interest litigation, PIL. Public interest litigation is a litigation filed by a public spirited person who does not have specific interest in the case. Public interest litigation is a litigation filed by a public spirited person who does not have specific interest in the case. The word public interest litigation do not find in the Indian Constitution. We cannot find the word public interest litigation in the Indian Constitution. Public interest litigation is a extra constitutional device used to protect the basic rights of citizens of India. Generally, in a case, a litigation is filed by the people who are involved in the case, who got affected by the case. Generally, in a case, a litigation is filed by the people who are involved in the case or who got affected by the case. This is called the principle of locus standi, LOCUS space STANDI. Locus standi means who are you in the case, what is your position in the case. Locus standi means who are you in the case, what is your position in the case. But in PILs they do not ask you who are you. In PILs the principle of locus standi is exempted. In PILs the principle of locus standi is exempted. They will not ask you who are you in the case. In India, public interest litigations are encouraged in 1980s by Justice Krishna Iyer, by Justice P.N. Bhagavati, by Justice Krishna Iyer, by Justice P.N. Bhagavati. 3 years back, there is a female lawyer called Pushpa Kapila Hingorani. 3 years back, there is a female lawyer called Pushpa Kapila Hingorani. She is considered as the mother of PILs. She died. Mother of PILs. See, PILs are encouraged in India. The reasons are many. In India, the first thing is people are illiterates and they do not know about their rights, and most of the people lack literacy, and we cannot expect legal literacy at all. We cannot expect legal literacy at all. Second thing is poverty. In India, litigation is very costly. In India, litigation is very costly. People cannot afford to go to court by paying lot of money. Second thing is litigation is very costly. First is illiteracy. Second is costly. Litigation is very costly. Third is indifference, apathy. Apathy means when some common issue comes into picture, when there is an area of common concern, people do not take a call on that. That means when there is a common ownership, for example, Ganga water is owned by the nation, Taj Mahal is owned by the nation. When something is owned by everyone, everyone disowns it. When something is owned by everyone, everyone disowns it. So, general public apathy. For all these reasons, we have encouraged public interest litigations in India. For example, there is a very famous case, MC Mehta versus Union of India, also called as Ganga water pollution case. Very famous case called MC Mehta versus Union of India, also called as Ganga water pollution case. Very famous environmental lawyer filed a public interest litigation for cleaning up of river Ganga, and the court said pollution free environment is a fundamental right under Article 21. And the court said pollution free environment is a fundamental right under Article 21. In the same way, you have PIL, Aruna Ramachandra Shanbag versus Union of India. Euthanasia is not a fundamental right. Euthanasia is not allowed. But in recent case, Common Cause versus Union of India, passive euthanasia can be allowed. In recent case, Common Cause, again a PIL. again a public interest litigation. And Shriya Singhal versus Union of India, Shriya Singhal versus Union of India, section 66A of IT Act. Now IT Act was again in news. Section 66A of IT Act was considered unconstitutional. Section 66A of IT Act obstructs the freedom of speech of individuals. So in Shriya Singhal versus Union of India, which is a PIL, section 66A was considered as unconstitutional. So private public interest litigations are being encouraged. At the same time, private interest litigations are discouraged. Initially, in a case called Sunil Batra versus Delhi administration, in a case called Sunil Batra versus Delhi administration, a postcard has been accepted as PIL. A postcard has been accepted as public interest litigation and supported prisoners' rights, and court gave guidelines for prisoners' rights in Sunil Batra versus Delhi administration. So PILs are being filed in many cases in India. For example, there are very recent cases with respect to LGBT rights, with respect to adultery, with respect to other things like suicides, other issues. Some of the cases have their initial support from PILs and some of them are directly PILs. In America, public interest litigations are called social action litigation. In America, public interest litigation are called social action litigation. Of late, public interest litigations are being filed for frivolous reasons, sometimes to take a revenge or vendetta, sometimes only to file a litigation. Courts are discouraging such private interest litigations, and sometimes court is awarding damages also. Court is awarding damage also under PILs, public interest litigations. This is all about public interest litigation. We can file PIL under Article 32 in the Supreme Court, under Article 226 in the High Court.